What is a financial settlement? This is an agreement that separating couples reach when they have been married. We can put this into what's known as a consent order, or you might have heard a clean break order. A clean break is where there's no further financial agreement between the parties, but you might have what's referred to as a consent order if, for example, if there is any further payments for the children or the spouse, which can be known as spousal maintenance. There's various ways in which you can reach a financial agreement. Some people prefer to reach the agreement themselves. We would say that this is only recommended if there hasn't been any issues of domestic abuse. And if you do feel that you are being pressured into reaching a financial agreement, then you should seek legal advice to help you with reaching that agreement. If the parties are able to reach an agreement together, you can come to us and we can draft that into a consent order for you. This is quite a complicated document that the court do refer to, and a lot of people do prefer to have a solicitor draw that up for them. There are various precedents, which are clauses that you can get online, so you can try and do this yourself if you feel that you are comfortable in doing so. Quite often, couples unfortunately can't reach an agreement together, and they do need our help in negotiating. If we are instructed to negotiate on your behalf, we would need full financial disclosure from both you and your spouse. This is a court requirement, and there are various documents that you will be required to provide, such as pay slips, bank statements, pension valuations, etc. If you do have a pension, it's not just from the current employer, it's also past employers. So you will need to try and get the valuation from each pension plan that you have, and you can contact them and ask for what's known as a cash equivalent transfer value. They would know exactly what you need and they'll be able to provide that. However, sometimes it can take them up to 4 months to provide you with that figure. So it is best to try and get that as soon as you know that you are in the process of reaching a financial settlement. However, it is worth knowing that if you do ask for a further valuation within a 12-month period, you will sometimes be charged a fee to obtain that. Unfortunately, not all couples are able to reach an agreement either with one another or through solicitors, and it might be necessary to ask the court to make that decision for them. It is a requirement to try mediation first of all, and there are also other alternate dispute resolution options, such as arbitration. If you do feel that this is an option that you want to go down rather than the court, then we can have a chat with you and discuss what would be best for you. If you do need to go down the court route, we can advise you every step of the way. We can also represent you in court so that that takes the stress away from you. However, you can do this yourself and act as what's known as a litigant in person. The court will explain what you are required to provide, and you will need to complete a Form E, which encloses all of your financial information, which I mentioned earlier. Each case is different, and we look at the situation as a whole to find out what you can afford to move forward with your life. And it's not always an easy conversation to have, but we are in touch with various other experts, such as mortgage advisors, tax experts, and pension experts. They can help you along the way so that you can make an informed decision going forward with your life following separation. As I mentioned earlier, drafting a consent order or a clean break order can be very technical, and we have a vast amount of experience in doing this. We can offer fixed fees to help you with drafting this document, and we would be happy to have a free initial consultation so that we can talk through your options. If you'd like to contact us by phone or email, please let us know and we can arrange that appointment. Thank you.